Okay, the first option considered, and there's a little snippet here from a prior written notice that the parent included in the question. In the first option considered. Let me go ahead and read it because I'm not going to include the image. But the option considered on the prior written notice is placement in general education with supplementary aids and services. And then their reason for rejection, mind-blowing, is due to the severity of the student's disability, placement in the general education setting with supports and services does not meet his needs. Okay, so back to the question then. They haven't even tried a one-to-one aid. Is their reason for rejection legal? From my understanding, they can't just assume due to the severity. Yes, there has to be, okay, let's start with least restrictive environment and then what is called in the law the alternative or the continuum of alternative placements, okay? So we presume competence, first of all, and the LRE requires that children be put in the general education setting to the maximum extent appropriate. Now that's the catch-all. What is appropriate? And so they're trying to say, well, due to the severity of his behavior, he can't be in there. So technically, that would be a correct analysis. But at the same time, what you would have to show as a parent, because, they're bulldogging you, all right? So that's where evidence comes into play. You can attempt to go back to your IEP team to address this issue, but at the same time, they may have boxed you into a corner to where you don't have any other option but to trigger your dispute resolution options, mediation, due process, estate complaints, office civil rights complaint, those kind of things. And if that ends up what you're doing it on the basis that you disagree with their placement determination into a more restrictive setting. Now, why did you do that? Well, because we have the continuum of alternative placements. And let's say the general education environment is this sliver of the continuum, okay? Now, over here on the extreme is on the extreme end is just any kind of neurotypical general education student that doesn't even have an IEP, because that is always the goal that we're working toward. We're always working our children toward not needing an IEP and those supports. So that is the optimal. All right. So anything outside of that. So if they just sort of shoved him in, let's say they didn't even put him in general ed and they just sort of made a call that, we just eyeballed and don't think that he could make it in there. Well, that's just wrong on its face. They got to give him an opportunity. Okay. But of course, they're not going to give him an opportunity unless you trigger the dispute resolution options. Because whatever determination, whether you agree with it or not, is going to be what happens unless you take that next step to dispute it formally. I know that sucks, guys. It does. It's a scary proposition to sit there and take it to the mat with these people, but they just can't write crap down that isn't true or not follow the law. But if people aren't going to be holding them to account on these things, then what you see, whether you agree with it or not, is what's going to happen. All right. So optimal, general education, and what points did they insert supplementary aids and services, and how long did they try those things? I had a case once to where they had a child in the general education setting, did an FBA, got the behavior plan in place, and 2 weeks later, the kid was out of there. The staff hadn't even been trained on the implementation, the correct and consistent implementation of that behavior plan. There was no opportunity given once the behavior plan was in place and agreed upon by the team. They didn't give it sufficient time to see if it was going to work. There was no data collection to support what they had done, but they did it. Now, was I able to reverse it? Of course I was. Because you got to give it a little bit more time. You know, and I know schools are sitting there going, oh my God, James, you know, you're asking the impossible that we keep these kids in the class, you know, to see if this stuff is going to work. Well, you should have done it right in the first place. Guys, you know, there is so much in the law that if you just did it right, if you just did it, then you wouldn't have all these problems where they're clearing your classroom. You know, if you had the right professionals, if your school system cared about you enough as a teacher, not to overload your class with too many special education students to where they're sprinkled among all of the general ed teachers for inclusion and not just concentrated in these globs like tends to be the pattern now. If you are provided the aide support and the outside professionals to come in to support through training the behavioral strategies that are needed, this isn't the kid's fault. All right? Kids are kids. Kids with needs. And I'm talking about any kid has needs. They're all dysregulated. Throw in special needs and some behavioral deficits. Don't blame the kids. Blame your employer. Blame your administrators. Blame your Board of Education. They're not supporting you as an educator. They're hamstringing you in your job. Don't blame the kids. You need to turn that focus on your union and on your administration, because your union's also not fighting for you. You know, with regards to encouraging the Board of Education to kick some more money down to sit there and support you with staff and support you with training. So then we end up with situations like that. And then, you know, what is severity? Define that for me. Okay? How are they defining severity? And where's the data collection to show where they've done even minimalistic exhaustion? You know, now are they required to have a one-to-one aide? Not necessarily. I mean, that's you know, there's no defined mechanism within that carve out of on the continuum of alternative placement. It's just got to be reasonable exhaustion to try to make it work. But there's no got to try this and you got to try this and you got to try this. But usually if there's aide support pushed in also with a proper functioning behavior plan where the staff have been trained to that plan, there's a lot of kids that are successful in those settings with those supports. But it's just getting there. So yeah, I mean, I see these kind of crappy prior written notices all the time, where, you know, the schools have been getting away with it for so long because not enough parents are holding them accountable to this nonsense and willing to take it to the next level in order to advocate for their child through disagreement. And how do you do that through disagreement? Due process, mediation, facilitated IEP meetings, calling another IEP meeting, independent evaluations for an FBA, and a good behavior plan where there's a recommendation from the, let's say, from the behavior analyst doing the FBA on recommendations for staff support and analyzing your child's ability to be successful in a general education environment. That can be part of your FBA determination and recommendation to your IEP team.